control of housing and work law. And this law really does do what it says on the tin in regulating these two fundamental aspects of human activity, and which, as has been said, have been the way in which immigration has been controlled in Jersey over the past decades. And I'm going to focus on the second aspect, that's to say the licensing of business. So, in essentially the same way as the regulation of undertakings law, the law works by prohibiting the carrying on of a business without a license. And it provides for three kinds of license: a business license, a non-resident license, and a hawker's license. Now, the most important is obviously a business license, which is effectively equivalent to what we colloquially refer to as a reg of uns license at present. And again, in similar fashion to the regulation of undertakings law, the law talks about an undertaking, and it's an undertaking which requires a license. What it tries to do, the law, however, is to define much more clearly than at present what an undertaking is. What it says it is a trade, business or activity involving work or services performed for or offered to members of the public or a section of the public carried on in Jersey by any person, whether or not for profit. So it's quite a comprehensive definition. It does spell out specifically that if no individual is paid to work for the undertaking, then there's no requirement for a license. So a charity with no paid employees doesn't have to have a license, but if there's one paid employee, let us say, with a charity, it will then have to have a license. And the law talks about business carried on in Jersey and has some provisions dealing with physical presence, which is the key here, which can involve, obviously, an address, actually what you'd understand to be a business trading in Jersey, but can also have a more extended definition where people associated with a business carried on, you might understand elsewhere, are present in Jersey, or in certain cases where goods or other items are in Jersey relating to the business. One of the important things, though, is to ensure clarity by providing for specific exemptions to make, really, essentially, to avoid unnecessary bureaucracy. And what the law provides for is the minister to issue guidance, or an order, I should say, listing exemptions. The draft law which accompanied, the report accompanying the draft law contained a draft order, but I think this has been refined, and the Population Office is about to publish the proposed final order in the next few days. So that will give about 6 weeks until implementation of the law, during which interested parties can comment on that. Broadly speaking, it'll be a case of certain financial services activities, essentially administering entities on the one hand, and sort of small-scale activities like cleaning services and such like on the other hand. So the application process, as has been mentioned, it's the Population Office, which is already the body which deals both with housing applications and with business licensing. It'll be a case of applying to the Population Office. There is provision in the law for fees to be charged, but again, in the next few days, we'll see the proposed fees order and know what the detailed proposals are in that regard. I think the policy intention was probably to avoid having to levy charges on making applications for business licenses themselves. I think the political thought was that it would be preferable to have annual levies in relation to license posts and therefore to reduce the burden on local business as such. So what the law sets out is criteria under which the minister has to determine the application. And these are quite detailed, and they include preserving and maximising the benefits of Jersey's resources, promoting a balanced and prosperous economy, protecting the integrity and reputation of Jersey in commercial and financial matters, and any relevant policies of the states of Jersey. So the tools are certainly there for the authorities, if they chose, to be quite micromanaging in this respect in terms of what kind of business activity to allow to be carried on. And we'll have to see politically how that's used. What the law does say, though, is that if the minister does grant a business licence, he can issue various conditions, but it's mandatory to specify the maximum number of individuals with licensed and registered status, so that's to say JCATs and non-qualified, as we currently understand them. It may be nil, but he has to say the number. And if any licence posts are permitted, each description of work that can be done by those persons. Now, what won't be controlled, as my colleague mentioned before, is the number of entitled and entitled for work persons. So essentially anybody with 5 years plus residency, there's no control on employing them. As you know, at present, you have a quota for qualified, quota for non-qualified, and have to go through the process. Of course, it's important to note that the conditions as to the employment of licensed persons is by reference to the description of work and not the individual concerned. And obviously this increases flexibility for employers. So let's say they have an allocation of 3 trust lawyers. They can choose to allocate them as they see fit without applying specifically by reference to particular named individuals. Registration cards, it's been mentioned, are very much the policing mechanism of the new law, and the law makes clear that both the undertaking can't employ somebody without that person producing a card, nor can somebody start new work without the card being produced. And there are some detailed rules as to what constitutes the starting of new work. And in both cases, it's a criminal offence on the employer's side and the employee's side for not producing the card or not seeing the card when it's produced. One of the most important changes to the regime is in relation to the change of ownership of undertakings. Because at the moment we have a split regime, which I think a lot of people would say is unfair and has arisen due to historical anomaly. Until about the year 2000, regulation of undertakings licences didn't contain any restriction on change of ownership. From that date, however, they've essentially usually required all changes of ownership to require the consent of the minister. But now we're moving to a level playing field and, in fact, a more liberal regime. The law introduces the concept of a significant change of ownership, which essentially means moving from local ownership below a threshold of 60% local ownership, that's to say entitled for work and licensed persons. And if you go below that threshold, that's when consent is required. The law sets out those rules in detail in relation to companies, and in relation to non-company undertakings, it's expected that there's to be guidance from the minister which will essentially mirror the same 60% rule. But listed companies don't have to require such a new licence. And as I say, the objective is to allow the minister in appropriate cases to prevent local businesses falling into non-local hands. So then just to look at existing undertakings, you'll all obviously be associated with existing businesses. And the law and the transitional regulations aim to move across from the existing regime to the new one. So every business with a current regulation of undertakings licence, and indeed with a staffing licence for those pre-1973 businesses, will be deemed under the new law to have a business licence. And the transitional regulations provide for the migration of existing J category and non-qualified entitlements, specifically by saying that the number of licence posts will be the same number of individuals permitted to work in or for the undertaking who are Regulation 11J persons. So if a business is entitled to employ 5 JCATs at present, even if they're not actually filling all those posts, that will be the quota of licensed posts. And similarly for registered, i.e. non-local employees. On the detail of JCATs, of licensed posts, the law says that any work of a general description comprised in a post to which a Regulation 11J person has been appointed by an undertaking shall be work of a description that may be done by licensed persons in or for that undertaking. So the idea here is that posts to which existing JCAT employees have been appointed set the rules, the parameters within which those licensed posts will be able to be filled in future. And the Population Office have said they intend to consult closely with businesses to make sure that it's absolutely clear what their existing J category permissions are going to mean under the new regime. Sorry. So I've tried to outline the key features of this new business licensing regime. And as I say, it's not conceptually a million miles away from the Regulation of Undertakings law. Some of the key same definitions, undertaking, etc., are still there. But I mean, there are some clarifications and there are some significant changes, particularly with the change of ownership rules, which I mentioned. And obviously, there are some improvements. Less bureaucracy in terms of no requirement to have a license to employ entitled and entitled for work only persons. And of course, this increased flexibility with regard to license posts, which I mentioned. I mean, there's obviously going to be, as with any regulatory overhaul, a period of acclimatisation over the next few months, and I know the Population Office is going to be keen to work closely with business, and obviously we at Appleby, get in the plug, will be happy to assist with any assistance that's required. Thank you.